It was a landmark 2017 Supreme Court of India judgment. The judgment established the right to privacy under Article 21 of the Constitution. The case arose from a challenge to the Adhar system. It reaffirmed that individuals have a constitutionally protected right to privacy, although this right is subject to all the limitations as are other rights. Thus, right to privacy is protected under Article 14, 19 and 21 of the Constitution. The original petitioner was Justice K.S Puttaswamy. He was a former judge of Karnataka High Court. In 2012, he had filed a writ petition. Over a period of 5 years, 26 other petitioners were tagged along with this case challenging the Adhar system. Retired Justice K.S Puttaswamy became a litigant for the first time in his career spanning 5 decades when he petitioned the Supreme Court challenging the linking of the state benefits with the UID scheme, saying that it was a dangerous project and much money had been wasted on it. He went on to say that the Adhar scheme had been rejected by the Parliamentary Committee on Finance, and yet the Union of India went ahead with it. How can such an awful project be implemented which has doubtful legislation? He argued passionately that it is a clear violation of a citizen's privacy. Justice K.S. Puttaswamy had filed a petition in 2012. On 24th of August 2017, the Supreme Court of India gave their verdict on right to privacy in the Justice K.S. Puttaswamy, retired, and others versus Union of India and others. It was a remarkable 547-page judgment in which the Supreme Court of India reaffirmed that the citizens have a constitutionally protected right to privacy under Article 21 of the Constitution. The 9-judge bench had given a unanimous decision. Justice K.S. Puttaswamy said, "I am vindicated." He further went on to say that had the Adhar scheme been voluntary, I wouldn't have petitioned against it. Now let us look at the background of the case. Facebook acquired WhatsApp in 2014. WhatsApp's data sharing policy was challenged in the Supreme Court. The Supreme Court had to decide whether a right to privacy could be enforced against the private entities or not. A 3-judge bench first heard the challenge to the Adhar card scheme. The Attorney General of India took the position that the right to privacy as a fundamental right was doubtful in view of Supreme Court's earlier judgments. On August 11, 2015, the 3-judge bench referred the question of right to privacy to a larger 5-judge bench. In October 2015, the 5-judge bench modified the orders and allowed the Government of India's request to bring other services within the scope of Adhar. When this case was on list in the Supreme Court, Chief Justice J.S. Keher was informed that earlier judgments from 8-judge bench and 6-judge bench had pronounced verdict against the right to privacy as a fundamental right. Justice J.S. Keher then decided to form a 9-judge bench. This bench was to decide on the question of whether the right to privacy is a fundamental right or not. The 9 judges in the bench were Chief Justice J.S. Keher, Justice Chalameshwar, Justice S.A. Bobde, Justice R.K. Agarwal, Justice A.M. Sapre, Justice R.F. Nariman, Justice Dr. D.Y. Chandrachud, Justice S.K. Kaul, and Justice S.A. Nazir. The 9-judge bench had to decide on 5 issues. These 5 issues were: number 1, whether there is a fundamental right to privacy under the Constitution of India. Number 2, if there is a right to privacy, then whether it has the nature of an independent fundamental right or whether it arises from a protected right already enshrined in the Constitution such as the right to life or personal liberty. Number 3, what is the doctrinal foundation of the claim to right to privacy? Number 4, what is the content of privacy? Number 5, what is the nature of the regulatory power of the state? The Parliament of India in 2016 passed the Adhar Act as a money bill. The then Rajya Sabha MP Jairam Ramesh then filed a petition in the Supreme Court challenging the Adhar Act 2016 as it had been passed as a money bill. What was the government's position on the right to privacy as a fundamental right? The Attorney General of India, K.K. Venugopal, was opposed to elevating the right to privacy as a fundamental right. The earlier Attorney General, Mukul Rohtagi, had outwardly rejected the elevation of right to privacy as a fundamental right. But K.K. Venugopal said that it could be made a fundamental right. On 24th of August 2017, the Supreme Court of India pronounced its judgment in the Justice K.S Puttaswamy, retired, and others versus Union of India and others. The Supreme Court opined that the right to privacy is a fundamental right under Article 21 of Right to Life and Personal Liberty, enshrined in Part 3 of the Constitution. The judgment mentioned Section 377 as a discordant note on the evolution of constitutional jurisprudence on the right to privacy. Among the 9-judge bench, Justice Dr. D.Y. Chandrachud authored for Justice Keher, Justice Agarwal, Justice Nazir, and himself. Justice D.Y. Chandrachud held that the Suresh Kaushal judgment of 2013 was incorrect. All the judges also expressed their disagreement with it. Justice Kaul was also in agreement with the view of Justice D.Y. Chandrachud that the right to privacy cannot be denied to an individual even if it affected a minuscule population of the entire majority. This judgment settled the position of law and clarified that the right to privacy can only be infringed upon by the state if there was a compelling reason to do so. The judges unanimously held that the right to privacy is protected intrinsically as a part of right to life and personal liberty as enshrined in Article 21 of the Constitution and as part of the other freedoms enshrined in Part 3 of the Constitution. This judgment overturned the judgment of MP Sharma versus Satish Chandra 1954, Khadak Singh versus State of Uttar Pradesh 1962, and ADM Jabalpur versus Shivkant Shukla 1976. Now let us come to the conclusion of this case. Number 1, the right to privacy is an inalienable right under right to life and personal liberty enshrined in Article 21 of the Constitution. Number 2, the right to privacy is inextricably bound to all the exercises of human liberty. Number 3, it is distributed across various articles in Part 3 and mutatis mutandis takes the form of whichever enjoyment of its right is curtailed. In order for the curtailment or infringement of the right to privacy, the entity as defined by Article 12 of the definition of state must pass the test as applicable to all other rights enshrined in Part 3 of the Constitution. In February 2020, the High Court of Nairobi, Kenya, referred to the case of Justice K.S Puttaswamy versus Union of India to hold that biometric data is necessary for the identification of a person, and it adopted the findings in the Justice K.S Puttaswamy case that other identification data is necessary for holding the identity of a person. This case became a landmark case in the history of India. K.S Puttaswamy died in 2024. Hi, I am Vishwajit and you are watching Landmark Cases.